Hello, everybody, and welcome to History/Law Bite number 268, dated June 1st, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Carroll versus United States, 267 U.S. 132, 1925. Carroll versus United States was a landmark U.S. Supreme Court decision that established what is known as the Carroll Doctrine, or vehicle exception to the Fourth Amendment's warrant requirement. All right, this is a landmark Fourth Amendment case that is rarely discussed, but this, folks, is the great granddaddy of all vehicle Fourth Amendment cases. All right, any cases involving vehicle searches under the Fourth Amendment are the progeny of this one, Carroll versus United States. All right, so we begin in the same manner that the Supreme Court does. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. All right, so let's get into the facts of Carroll versus United States. This case began, all right, in the early 1920s during the Prohibition era in American history. You all are quite familiar with that, I'm sure, all right? So in 1919, under the Volstead Act, the act enacted by Congress, officially known as the National Prohibition Act, that act authorized warrantless searches of airplanes, boats, and vehicles, okay, if there was reason to believe that they were transporting illegal liquor, okay? So in this case, federal officers arranged an undercover purchase of liquor from this individual named George Carroll, all right? He was a shady character involved in the alcohol black market, all right? The transaction, however, was not completed. And so, later on at some point, they managed to catch up to Mr. Carroll on a highway in between Detroit and Grand Rapids, Michigan, all right? Having their, reasonable suspicion to believe that he was probably transporting the illegal liquor. They intercepted his vehicle, stopped him and searched the vehicle, and voila, ladies and gentlemen, they came upon a whole swath of illegal liquor. What a surprise from a guy who was in the illegal liquor trade, huh? All right. So, with that in mind, Mr. Carroll would be indicted in the United States District Court, all right? After his indictment, his lawyers filed a motion to suppress and return all the evidence that they had found in the car, the illegal liquor, of course, as they contended that the cops didn't have any authorization to search his car in the first place because they didn't have a warrant, and thus it was a clear violation of the Fourth Amendment. The trial judge denied the motion, and with that, Mr. Carroll was prosecuted and convicted for violating the National Prohibition Act, all right? As such, he and his co-defendant appealed to the Supreme Court of the United States. The singular question presented to the justices was this: did the warrantless search of Carroll's vehicle violate the Fourth Amendment? In a not surprising 6-2 decision, the Supreme Court ruled that it did not. The majority opinion by Chief Justice, and former president, by the way, William Howard Taft, contained the following points. Taft reasoned, quite logically, that the warrantless search of an automobile does not violate the Fourth Amendment, as a vehicle's movable nature made it impracticable to obtain a search warrant, okay? Vehicles, therefore, could be searched without warrant, folks, if probable cause existed to believe that evidence was indeed present in the vehicle. All right. This was tied with exigent circumstances. All right. And that was essentially to believe that the vehicle could be removed from that location before a warrant could be obtained. All right, so those are the exigent circumstances. Exigent in this case meaning emergency, immediate, urgent. All right. So, but the court also ruled that this was not a green light for law enforcement to search any and every vehicle just because they had a presumption of some kind that it could be containing alcohol, all right? But instead, some sort of actual probable cause, all right, had to exist to believe that the vehicle was carrying some sort of illegal contraband, all right? You know, it was, law enforcement was not given a green light by the court here to just stop every car and search it. No, the officers had to have some sort of probable cause to believe that the vehicle in question was carrying some sort of illegal contraband, all right? The court emphasized that where the securing of a warrant was reasonably practicable, it must be used, okay? The ability to search vehicles without warrant, if there was probable cause to believe evidence was present, coupled with the exigent circumstances, all right, to believe that the vehicle could be removed from that location before a warrant was obtained, became known as the Carroll doctrine, all right? Thus, the ability to search vehicles without warrant, all right, as long as there's probable cause to believe that the vehicle contains some sort of evidence or illegal contraband. All right, this is the Carroll doctrine, or what is known as the vehicle exception under the Fourth Amendment's warrant requirement. Okay, so everyone didn't agree with Taft's rationale. Two dissents were filed by Justices McReynolds and Sutherland, who were not as willing as Taft was to disregard the warrant requirement to search vehicles. All right. So, in sum, the holding of the court in this case was that vehicle searches without a warrant were constitutional under the Fourth Amendment as long as there was probable cause, some sort of true and definitive probable cause to believe that they were carrying some sort of unlawful merchandise. All right. In the case of Carroll versus U.S., it was liquor. But of course, Carroll versus U.S., like I said, is the great granddaddy of all vehicle search cases without a warrant, all right? And since Carroll, which at the time of this recording was handed down 96 years ago, okay, there have been a litany of different Supreme Court decisions that have both expanded and limited the abilities of law enforcement to search vehicles, all right? All of those decisions have their own unique particulars based on context and circumstances involved, okay? So that sums up Carroll versus United States. Once again, that in a vehicle search, all right, it is constitutional and not therefore a violation of the Fourth Amendment for an officer to search a vehicle without a warrant as long as there is sufficient probable cause to believe that the vehicle is containing some sort of illegal contraband, all right, or some other illegal items, all right? That is Carroll versus United States. And like I said, this decision has been followed by many subsequent cases involving vehicle searches without warrant. Okay, so if you have any questions or controversies, leave them down below and I'll be happy to answer them. If you learned something from this video, gained some insight from it, drop me a like. I would appreciate that. And if you've not subscribed to my channel, please do so now. Your support means more than you will ever know. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.